It's pretty much acknowledged that the founding fathers had to be geniuses to write the Constitution, but actually in a way they blew it, right? No Bill of Rights.
They blew it in a really fundamental way. They met between May of 1787 and September, and they produced, by all accounts, the world's best Constitution. But they left without creating a Bill of Rights. It's almost impossible to make sense of this, that the founding fathers, living in the age of the rights of man, just a few years after the Declaration of Independence, produced this great social compact, but they didn't enumerate the specific rights of American citizens.
Why do you think that they missed that?
Oh, a number of reasons. First of all, they were tired. This had been a long, difficult process. Big states, little states, slavery, how we're going to make all this thing work. What's the president going to be? What kind of separation of powers are we going to have? They were exhausted and ready to go home. But secondly, some of them, including the great James Madison, the father of the Constitution, argued that if you create a Bill of Rights, you're inviting trouble, that it's better not to touch that area because people have their inherent rights. Even to presume that the national government should discuss this is in a way curtailing our natural rights. And so he called it a parchment guarantee. And he thought that it was really more trouble than it was worth, and it might backfire. And that, by the way, is what led to the Ninth Amendment, which says this is not necessarily the last word on human rights. This is this compilation of rights.
How did the public rise up and demand this?
Well, that's so interesting, Sam, because the Founding Fathers met in secrecy. The first thing they did when they met was to close the doors. They actually had earth put on the streets outside so that they wouldn't have a lot of traffic noise, and they swore that they wouldn't discuss the deliberations outside of that room. The sense was, you don't want the public getting involved in this. It's too crazy, and they needed to preserve the possibility of changing their minds. So, secrecy rule. Once the Constitution was finished in September 17th, 1787, it starts to circulate, and the people are angry because they think, wait a minute, we liked the Articles of Confederation, a kind of a cluster of states. Now there's this strong new central government, and in addition to that, it doesn't even bother to protect us against a government that might get out of control. And so the people said, look, we will ratify this thing, sort of holding our nose, but we are not going to ratify it unless a Bill of Rights is appended in some way to it. And that's really what led to the Bill of Rights being passed by the first Congress of the United States.
Well, let's go through the amendments one by one.
Great, 10 amendments. There were some 200 proposed amendments. James Madison whittled them down and got them down to around 18, 17.
On his own?
On his own. He was the master of this. He was the author of the Bill of Rights. And he didn't want to do it, Sam. He really thought that it was unnecessary and maybe even dangerous, but he said, he called it a nauseous duty. But he decided he had promised to do it, and he would do it. He whittled them down to 17 or 18. Congress actually sent out 12. 2 didn't pass, but here are the 10 that did. Of course, the First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. Maybe the most important of the whole bunch. And a cluster of things, as you see, not just one. The Second Amendment. This is a really important one to get right, so I'm going to read it. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Notice that it's not a blank check on guns. It says, because we want a militia and not a permanent military establishment, the people shall have the right to keep and bear arms.
In 2008, as we record this becomes such a nebulous area.
We have no militia. We have the National Guard and the National Reserve, which are in some sense echoes of that. But you know, Sam, they don't provide their own guns. I don't take out my rifle when I go into the National Guard. So this is a historically contingent amendment that was really designed to prevent a permanent military of the kind that you and I take for granted. So whether it's, strictly speaking, still fully valid in the 21st century is an interesting question that I'm sure we'll get back to. The Third Amendment is unique. It has never been the subject of a court case. not once in American history. It says, no soldier shall in time of peace be quartered in any house without the consent of the owner. That's back during the Revolution and before. The British used to quarter troops, put troops in people's private houses and not compensate them. That was prohibited. Number 4 is another extremely important one. It prohibits unreasonable searches and seizures. It requires a search warrant, and it goes on to say that that search warrant has to specify what it's looking for. You can't go on a fishing expedition into your house. If government wants to go into your house because they think, let's say you have drugs or illegal weaponry, they have to get a search warrant. They can't just knock down your door, and they have to say what they're looking for. They can't say, we think Sam's probably a criminal. They have to know in advance what the thing they want to find.
Okay, but now since 1978, without looking at the politics, but just looking at the legalities of it and how it bears on the Constitution and the Bill of Rights, you have a FISA court that now says that you can go do what you need to do, but you have several days to be able to come back to us and get our permission after the fact. What would the Founding Fathers have thought of that?
Danger, and they would have been appalled by this. But we don't live in 1787. You know, I'm going to say this many times, Sam, it was a 3-mile-per-hour world. If Napoleon had wanted to invade America, it would have taken him 2 months to get troops here. A high-tech weapon was a musket that you had to reload. It took 20 or 30 or 40 seconds to reload. There were no cruise missiles. There was no nuclear weaponry. There was no anthrax. You know, we're living in a 21st century world trying to govern ourselves with an 18th century document, and that document protected the rights of the accused for that time and that place. But remember, even these surveillance systems you're talking about don't apply to American citizens except under the most extraordinary circumstances. They're basically about foreign residents or foreigners in our midst. They have to specify that they're about terrorist activities. They're not about drugs or maybe some other illegal act, the way you fence your yard, or whether you're keeping a hog in a place that's zoned for something else. These are about national security issues. And one of the things you learn in studying the Constitution is that the courts have been very lenient with government when it comes to the security of the American people. They allow the government to take more power than the Founding Fathers would have been happy giving them. Anyway, that's the Fourth Amendment, extremely important. The Fifth Amendment, everyone knows I plead the Fifth. The Fifth says you can't have double jeopardy. You can't be tried for the same crime twice. You have a right to a lawyer. You have a right to confront your accuser, and you can, if you wish, say that you will not testify against yourself. So extremely important, protecting the accused against double jeopardy and other judicial abuses.
In 2008, the United States Supreme Court heard the landmark gun control case, D.C. versus Heller, and legal scholars were busy debating whether the Second Amendment is an individual right or a collective right. What does that question mean? And what language in the Second Amendment prompts it? What arguments can you think of to support either side of this question? Why did the Sixth Amendment deal with speedy trials? What was the problem that this was going to resolve?
Well, there's several things, Sam. One is it had to be a trial in the state where you were accused of committing a crime, because before the Revolution, the British were taking American citizens across the Atlantic Ocean to be tried in London, not by their peers. And of course, that would mean delays of months, sometimes years. So you're entitled to a speedy trial. Of course, there's a lot of court controversies to try to define what speedy means. You're entitled to be tried in the district where all this occurred and by a jury of your peers, actual fellow American citizens of the place where all this occurred. Extremely important.
Okay, Seventh Amendment.
Seventh is less interesting. I'll just quickly paraphrase it. It says that in common law suits, you are also entitled to a jury trial if the cost, if the dispute is over $20. But it means that these things aren't just done by star chambers or by administrative judges, that you can get a jury in a trial that involves not crime, but common law traditions. So that's the Seventh. The Eighth Amendment has been extremely important, heavily contested. Excessive bail is not permitted in the United States, and of course, you are not given a cruel or unusual punishment. whether capital punishment is cruel and unusual has been one of the debates of the 20th century.
Well, now, taking a look at this from a historical perspective, again, we're talking about this in 2008, again, without looking at the politics, but just looking at the situation where you have an offshore location where the government sets up any kind of interrogation and utilizes things that may be perceived as torture. How does this play into what we look at with the Bill of Rights?
Well, these people that are being detained and presumably interrogated with methods that are called torture by some, they're not American citizens. So they're not entitled under our social compact to the same rights that you and I are entitled to. But libertarians and believers in natural rights say, wait a minute, this isn't just an American code. This is a code that belongs to mankind, and this is America's articulation of it. And a person who is suspected of Islamic terrorism is as entitled to these protections as you or I. And a strong case can be made for that. But one thing that the current administration has done, and others too, is you get these people offshore. You put them into military situations rather than civilian situations, so you can emphasize their otherness. It would be very hard for you to be waterboarded or for me to be waterboarded because we have these protections. Foreign nationals, it's a whole different zone.
So let's move on to the Ninth Amendment.
The first three were sort of these universal rights, freedom of press, freedom of assembly, freedom to petition, and freedom to have guns. Then 4, 5, 6, and 7 are really judicial procedural things. What are your rights when you're accused of a crime? That shows you how important the Founding Fathers felt about the rights of the accused. Then the last two amendments are to try to persuade skeptics that the Constitution is not dangerous. The Ninth Amendment says that this list of rights is not the last word. It's not meant to be exhaustive. It says specifically, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. That just means that the people can rest easily because this is not meant to be the only list of their rights. And then the 10th, extremely important, and particularly to Thomas Jefferson. The powers not delegated to the United States by the Constitution nor prohibited by The powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. In other words, the Constitution of the United States enumerates certain national powers, but the states still have their sovereignty, and anything that's not listed in the National Constitution of the United States still belongs to Virginia or Maryland or New Hampshire or South Carolina. Arguably, from the point of view of the ratification of the Constitution, that's the most important of all the amendments. It says the national government is not going to swallow up America. Virginia still matters. Nevada still matters. New Hampshire still matters.
But how does this apply when the federal government is able to withhold funding for things perhaps like transportation if states do not go along with what the national outlook is?
The 10th Amendment, from a Jeffersonian point of view, has largely been swallowed up in the course of American history. Hamilton, in a famous speech at the Constitutional Convention, said, let's reduce the states to mere administrative units. And that's effectively what's happened. But remember, the 14th Amendment came right after the Civil War, and the 14th Amendment essentially nationalized the whole country and said what goes on in Tennessee is the business of the United States government. So it extended the protections of the U.S. Constitution to states and localities, effectively swallowing up the 10th Amendment. It's not a dead letter. It still gets invoked all the time, but it has less potency than it did when it was ratified in December of 1791.
Now, you talked about how when they started out with these, there were 200 that were offered in the Bill of Rights. What were some of the ones that were left out, and how close were they to getting in?
Well, not much that was left out got very close, because Madison was an extremely shrewd man. But there was going to be non-re-election of the president. There were going to be provisions for conscientious objectors during times of war, a whole series of things about procedures, the Electoral College, how the Senate works, and so on. These were anti-federalist amendments by states that were worried about what the new national constitution meant. But what Madison did was say, let's look at the ones that have eternal value. Let's look at the ones that will quiet criticism of the Constitution and remind people that their rights are not going to be obtruded upon by this new National Social Compact. So he was a genius. And you know, the funny thing about this, Sam, is that he didn't want to do it. The first Congress of the United States didn't want to do it. He stood up on May 4th, 1789. He was a representative from Virginia. He said, I apologize, I have to do this. I kind of promised I would do it, but in about a month I'm going to present to you these proposed amendments. And the rest of the Congress said, oh, you know, we have tariffs to think about, and we have funding to think about. We have to set up the judiciary. We don't have time for this. This is just nonsense. Well, historically, the Bill of Rights has become at least as important as the Constitution of the United States, but none of the people who gave it to us wanted to produce it. It was sort of an annoying thing that they had promised they would do.
Remarkable for an annoyance. But the judiciary at this point wasn't even set up.
The judiciary, the Constitution is a very general document, about 4,000 words in length. It set up a judicial system. That's Article 3. Article 1 is the legislative. Article 2 is the executive. Article 3 is the judicial. But it only says you can have a Supreme Court and such other courts as Congress may decide. It didn't say how many members of the Supreme Court. It didn't say how long a Supreme Court term would last. It didn't say what the powers of the Supreme Court would be. The Supreme Court was the only enumerated piece of it. And then the first Congress of the United States had to sort of put bricks and mortar around those vague concepts and create a judicial system. So it created the first circuit courts, and it decided that Supreme Court justices would ride circuit, that they would actually go on tour to be in the states that they represented and so on. But all of that was left out of the Constitution itself.
In discussing each amendment in the Bill of Rights, Clay says repeatedly, this amendment is very important, which leads me to suggest this is a great discussion topic. Which amendment to the Bill of Rights is the most important, and why? As we've shown here, the Constitution is a living, breathing document. The Bill of Rights live and breathe as well. And they're not just something that's a couple hundred years old in history. They apply as much today as they did when they were first written. And we can see an example in modern day with Mark McGuire and the Fifth Amendment.
Ken, let me just say you're absolutely right, Sam. You know, we think of the Constitution as something written 200 plus years ago, but it's still the way we organize our lives, and our most precious protections as American citizens come directly from that document. So this is not a civics lesson. This is about our rights, how we go about electing our president, how we settle disputes between states, how we separate powers between the three branches of government. And you see these things come up again and again and again. Take the Fifth Amendment. That comes back to the Mark McGuire case. You know, you see these programs like Law and Order, and someone is accused and saying, I plead the Fifth. I am invoking my Fifth Amendment rights. That's a very important American protection found in the Bill of Rights. So Mark McGuire, the home run king, is accused of having taken steroids. He was brought before a House committee. Jefferson might wonder why a House committee is investigating baseball, but still, in 2005, he was before the House Government Reform Committee, and he was asked whether he had taken steroids. And he said, and I quote, "My lawyers have advised me that I cannot answer these questions without jeopardizing my friends, my family, and myself." Translation, he was under oath. He did not want to answer the question because he would, in fact, be incriminating himself, not to mention shattering his reputation as a great baseball player, if he admitted to taking steroids. So he pleaded the Fifth Amendment. Now, he didn't say it in quite those terms. So then one of the congressmen said, are you pleading the Fifth? And he said, I don't want to talk about the past. I want to talk about the future. But he was, in fact, doing what millions of Americans have done, pleading the Fifth Amendment. That's why the Bill of Rights is important. What would Mark McGuire know about the Fifth Amendment if there weren't one? Madison said, well, we don't need to write all these things down. These are the rights of the people. The government should never even list them. But Mark McGuire had to have something to invoke. And by having this written down in this way, when my free speech rights are abridged, I can say, hey, the First Amendment says I have right to freedom of the press. When someone wants to take my gun away, I can say, hey, the Second Amendment says I have a right to this. When someone wants to fine me $100 million for a parking violation, I can say cruel and unusual punishments are not allowed here. So the Bill of Rights is the people's charter that gives us language to invoke in public, saying, wait a minute, I know what my rights are in my heart, but it doesn't hurt to have them in plain English either. You know what's so astonishing, Sam? The Bill of Rights has only 413 words in it. The 10 amendments that are the most important part of our jurisprudence, 413 total words.
And when you think about some of the bills that have been passed over the last few years, thousands of pages, let alone thousands of
The
words.
agriculture bill, 10,000 pages or whatever. The Bill of Rights, this very simple articulation of things, and it has done more to protect us than anything in the Constitution itself.
Let's talk about the First Amendment. Judge Moore in the State House case.
Oh, this is such a wonderful separation of church and state case. Judge Roy Moore of the Alabama Supreme Court, he was the Chief Justice, had been sporting for a long time to restore God to the Constitution. So even though he had had some squabbles over this, he decided that he was going to get a 5,280-pound monument built with the Ten Commandments chiseled into it. And just to add a little, to protect himself, he had some sentences from the Declaration of Independence and the Gettysburg Address and so on. So the ACLU in Alabama, together with other civil rights organizations, filed suit against him for violating the Establishment Clause, the First Amendment, back to this written
What does
language.
that mean?
The Establishment Clause says that the government of the United States cannot establish a state religion. And the courts over the years have interpreted that to mean that if you put out the Ten Commandments, you are in a sense endorsing the Judeo-Christian tradition as opposed to, say, the Islamic or the Hindu or the Zoroastrian or the Sioux Indian religious tradition. So the courts, especially since the 1960s, have said there's no place on public property for invocations of the Judeo-Christian tradition unless that property also invites every other tradition to put up their monuments, which Judge Moore did not, of course, want in Alabama. So just to kind of mess with the system, he puts up this 5,280-pound monument. The ACLU filed suit. The 11th, it went through several rounds, but finally the 11th Circuit Court of Appeals said it had to be removed. And furthermore, it said every day that the state of Alabama kept it there, the state would be fined $5,000. So now Alabama has reason to repudiate Judge Moore, and they did. It was removed, and he was himself removed on November 13th, 2003 from the Chief Justiceship, from any justiceship in the Alabama Supreme Court system. Here's what's interesting. 88% of the people of Alabama believed it should stay. That's another reason why we need a Bill of Rights. Popular majorities are not always right about the Constitution. The courts and the Bill of Rights sometimes have to check majorities and say, wait a minute, it may be popular, it's still not fair. And so 88% of the people of Alabama wanted to keep it. Then he ran for the governorship of Alabama and he lost by a 2-to-1 margin. So in a certain sense, the people also said, he's an annoying guy.
Let's talk about something that has been a big issue over the last few years, which is guns in schools. And how does that apply to the Bill of Rights? Because it's such an emotional topic.
We've just seen this again. This is happening now almost once a month somewhere in America, and not just in America. We have no capacity to stop this. And in fact, there have been several court cases where there have been strikings down of laws, local laws, that prohibit guns within X hundred feet of schools. We're probably heading towards an airport sort of system, Sam, where you'll have to go through metal detectors to get into schools in these places. But they happen as much in rural America as they do in urban culture. And this is a society that loves its guns. You would think that a school would be a place where guns could safely be prohibited, but the Second Amendment is a pretty strong amendment. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. You know how much Americans love the Second Amendment. The NRA is a very powerful and effective lobbying group for Second Amendment rights. And people they feel more strongly about the Second Amendment than almost any other one in the Bill of Rights. And so government at all levels has been pretty reluctant to get in the way of your gun or guns.
Yet it's interesting, in Los Angeles during the riots, the Rodney King riots, the military came in and all the guns in LA didn't mean anything because they were staring down a tank that was provided by the government, which I found to be very interesting.
Well, so you're going back to Jefferson's point. Madison's point would be, we need to avoid a standing army, therefore we need a militia, therefore the people need to have guns. Jefferson's point was, a free man is a man with a gun. Jefferson thought, well, you may need to bring down your government from time to time. So Jefferson likes guns because they're part of our right to rebellion. Madison would have cringed at that sort of a notion, but you're rightly saying that in the 21st century, what is a musket compared to a tank or a cruise missile or riot guns and so on? People have a kind of irrational zeal about the Second Amendment, but it is a very powerful one, and anyone who gets in the way of that is probably going to lose the next election.
Pretend you're in the Continental Congress and there's to be an 11th Amendment in the Bill of Rights. What right would you add? And defend the need to include it.